So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Because you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
Buckle up, guys. Today we're going to witness confusion turned hook. The defendant's frantic, "Am I free to go?" opens the scene and immediately raises stakes. You hear procedural friction, bond, self-representation, and a sharp rush to establish who's in charge. This clip gives the audience an instant why to watch, a raw, human moment that previews courtroom chaos and sets the emotional tone for everything that follows.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus.
Here the court lays out the charges and penalties, while the defendant insists on self-representation. As a third-party observer, note the contrast: formal legal language versus a person choosing to waive counsel. That tension, procedural warning versus personal resolve, signals risk. The judge's clear explanation of consequences anchors the narrative, giving viewers context for why later actions and mistakes have serious legal weight.
Court cost. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you,
I served 30 days already.
and if you serve 30 days, it may count.
This segment tightens the atmosphere. The judge warns about self-representation standards, and the defendant presses about time served and bond. From a detached angle, it's a study in misunderstanding. Legal rules collide with lived experience. The defendant's repeated bond questions and the court's procedural replies show early communication breakdowns that foreshadow later conflict, making it essential viewing to grasp motive and confusion.
I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. If I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
The courtroom pivots when someone suggests listening to a recording. As an outsider, this is the precise moment words risk becoming evidence. Tension spikes because a decision is made to move from argument to audio proof. You can almost feel the shift. Speculation gives way to potential confirmation. This clip is the ignition point where the narrative moves into investigatory mode, and the judge prepares to consider hard facts, not just allegations.
You've got to make a decision, man.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, man.
It could have a jury, fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she ain't got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
The court reconvenes, counsel reassembles, and the judge reasserts control. Observing neutrally, this is where formal proceedings reestablish order and the stage is set for adjudication. The short exchange recalibrates the room, attendees refocus, the hearing scope is clarified, and everyone braces for the recorded evidence to be weighed. It's the calm before the decisive moment. The tension is quiet but palpable.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by parody. The whole
That's-
McDonald's thing and then this. And...
This-
Okay, let's try this one.
Before he makes more statements.
And I did record the-
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because he's interfered with it.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes,
Okay, could you please state your name?
literally.
What is that noise?
Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop this.
It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, you are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMV against Mr. Lee. Mr. Lee contacted Mr. Rabo and offered to essentially not testify in that case.
Prosecutor and counsel summarize the recording's content, and you can feel the legal framing tighten. From an external perspective, this clip is critical because it translates an audio fragment into an allegation. Quid pro quo, witness tampering. The courtroom moves from curiosity to concern. The prosecutor's concise description primes the judge to see this as more than argument. This is potentially criminal conduct with immediate consequences.
If Mr. Kwasny agreed not to testify in this case, there are statements that are essentially saying, in exchange for Mr. Kwasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want it documented for potential additional charges. But this all happened, transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one of you
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's her name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact.
The judge and prosecutors escalate the language. Clear attempt to tamper, circumvention of counsel, and obstruction. Watching objectively, this is where the story tilts toward consequence. Legal terminology becomes action. Revocation, bond violation, obstruct. The court's intensifying tone signals the kernel of judicial response. This is the sequence that forces a decision and reveals how the system treats alleged interference with witnesses.
The lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was,
Mr. Lee, no, to my knowledge, no.
so I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
He might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those.
Early in the record, the defendant or a participant states, I recorded the call, and that admission is pivotal. As an observer, you should mark this as the first time raw allegation becomes tangible claim of evidence. The speaker insists the recording proves a point and urges counsel to listen. This clip gives the viewer the moment of evidence origin, when suspicion becomes something potentially provable, raising the stakes for everyone in the courtroom.
Those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you.
Thank you. Somebody needs to listen to him.
Yes.
Just listen to it. Have you heard him? Or?
Just now. Oscar and I listened to it together.
Okay. It's like, all right, I'll recall that momentarily.
And then everyone else gets folded.
Everybody else is holding back. Andrew.
Mr. Kennedy.
Four.
Yeah.
Okay.
Yep.
So this one we're going last. Right now.
No. This one.
That's
This
fine.
last.
So just hold down.
Yep.
Then it's between these two. What happened to verse?
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow. Okay. All right, but this one has one. And then we gotta bring Lee back out. So who's on this one?
This is 4 witnesses with Miss Tanha and I believe Miss Ackerley.
So then this is good night.
9 is Burkett.
How many witnesses on that? One witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm gonna take a brief break. We'll handle that one. Then I'll get Mr. Lee out. Or Okay,
Thank you, Your Honor.
and deal with Lee.
That's my order then.
All right, court is standing Larry Lee.
All right.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wear a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
The defendant explains why he recorded the call and reveals he checked with the other attorney. The exchange confirms the other counsel had not been contacted. From a third-person perspective, this is motive plus verification, mistrust of counsel, active steps to document communication, and corroboration from the opposing attorney. It's human drama and procedural proof in one. Motivations exposed and the recording's relevance made concrete.
Oh, there you
Good
go.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Robles sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Robles, who's attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Robles has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Quasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney.
This is the climax. The judge announces she's listened, finds the call indicates an attempted exchange, and orders the defendant's bond revoked and phone privileges suspended. Objectively, this is the system's decisive response. Evidence met with immediate sanction. The ruling provides resolution to the developed arc and demonstrates consequences for alleged witness tampering. This clip closes the story with clear judicial authority and real-world impact. If you enjoyed this breakdown, like the video, subscribe to the channel, and we'll see you in the next video.
And right in the phone call,
Because it would have been unethical for Mr. Burgess to try to call to try to say my client won't testify in this other matter,
Of course.
if that, right? That's
Well-
what Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to
if I
make
may.
a record. What, could I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. The call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with interrupting.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quasi, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quasi not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages.